Mediation, making new personal injury claims less stressful. The legal system has seen a move away from the time-consuming and stressful settings that are involved in personal injury claims. Now there is an alternative way of dealing with disputes by using mediation. If you have reached a standstill in negotiations because neither side can come to an agreement, mediation may be the only way to go. The good news is that insurance adjusters and lawyers recognize how valuable mediation can be, which means even if your case appears to be going nowhere, there could still be options to consider. How mediation works. When two parties have failed to reach an agreement, a mediator will help them to come to a mutual and satisfactory solution. Mediation is completely voluntary until the dispute is taken to court, and mediation will only occur if both parties, the plaintiff and the defendant, agree to it, and a dispute will only be settled if both parties agree to the settlement. The trained mediator will not give opinions or make decisions regarding the personal injury case. They will simply work with both sides in an attempt to reach a settlement. If neither of the parties agrees to a solution, they will both go back to the stage they had reached before mediation began. One of the benefits of using a mediator even if no settlement has been reached is that nothing that was said during the mediation will be used should the claim go to court. Who pays for the mediation? The cost is usually split between both sides, meaning that both parties will pay 50% of the costs. The process itself is quite informal and it allows every party to have their say without having to worry about legal procedures and saying something that could make them lose the case. This is often why people are happy to pay for mediation. What mediation involves? Mediation tends to involve a simple structure, especially in personal injury cases. However, they can vary a little depending on the mediator. For the most part, each party has a chance to speak to the mediator while the other party is present. The mediator will listen to one party's side of the story, and then ask the other party to speak. The two parties can technically speak to each other, but only through the mediator. Each party will also get the chance to speak to the mediator alone. The information that is given to the mediator will be given in complete confidence. Once the mediator has gathered all the information together from either side, they will try to gently coax both sides to change their position just enough so that an agreement can be reached. During the coaxing stage, there are no limitations as to what the parties can say or how they present themselves. Where to get mediation? Mediation can be found in community resolution centers that train volunteers in dispute resolution. The volunteers are not legal professionals or professional mediators, they are usually people who are interested in mediating and want to help. Resolution centers don't usually charge very much to hire a mediator, and they tend to mediate disputes that are taking place between landlords and their tenants, neighbors, contractors, businesses, and consumers. You should be aware that many of the mediators who work in community resolution centers don't tend to have a lot of experience with personal injury claims, particularly those that are made against insurance companies. When you need the help of a professional mediator. If you need the help of a professional mediator, you should be prepared to pay in excess of $300 per hour. Professional mediators are usually former lawyers or retired judges, but they can also be full-time mediators who have a legal background and a lot of experience. Many professional mediators have a lot of experience in dealing with personal injury claims. The advantages of mediation. If your personal injury claim has reached a standstill and you cannot agree to a settlement with the insurance adjuster, mediation may be the way forward. The advantages of mediation are: the insurance adjuster sees you face to face, making you more human rather than just another personal injury claim. The insurance adjuster has to try a lot harder to settle the claim as they need to be seen as being helpful. You don't always need to come up with arguments for your case. You don't always have to produce documents that you would otherwise need to in court. The mediator can help to move things along, rather than you having to take the claim to court. The disadvantages of mediation. Mediation can be quite expensive if it lasts more than 2 to 3 hours. It may be hard to find a cheaper community resolution service. An insurance adjuster may not agree to mediation because it involves a lot more work. Should you use mediation? You may want to think about using mediation if neither parties can agree who was to blame for your injury. If there is a $2,000 difference between the settlement figure you want, and the figure the insurance adjuster wants to give you again, you may want to hire a mediator to help. Lastly, if you have reached a standstill in your negotiations, again, a mediator may be worth hiring before you consider taking the claim to court. If you think you need to hire a mediator, please be prepared to talk openly about your slip and fall. You should also be prepared to pay the cost of hiring a mediator, regardless of the outcome of the mediation.